Mr. Mooppan.
Mr. Chief Justice, and may it please the Court. I think this Court's predominant standard will help clarify a lot of the issues that have been discussed this morning, and will also show why the arguments we're pressing here were neither raised nor rejected in Milligan. So first, under the Constitution, the problem is not the mere consideration of race in districting. The problem is when race subordinates traditional neutral principles and is the factor that cannot be compromised. Second, the problem with Section 2 and Jingles is not that it's an effects test. The problem with the statute is, as construed in Jingles, it's reaching far beyond anything that can reasonably present a risk of intentional discrimination, as in fact making race predominant, is requiring states to subordinate their principles to find a result. The Robinson litigation perfectly exemplifies this. The Robinson plaintiffs could not show a denial of equal openness for black Democrats. What they could show is that Democrats in Louisiana lost a seat. I welcome this Court's questions.
In one of your suggestions in your brief, you mentioned decoupling race and party. One, is there a correlation, particularly among black voters? And two, how do you decouple them?
So there generally is. The way you would decouple them is you look at primary elections, right? You look to see in the Democratic primary, do white Democrats and black Democrats vote differently? And that did not happen here. If you look at the Robinson District Court opinion, when they do the steps 2 and 3 of Jingles, and they analyze racially polarized voting, the Court expressly said they didn't need to try to decouple race. And they did that because in Jingles, the Court never resolved the issue. Justice Brennan said you didn't need to do it, but Justice White refused to join that part of his opinion. And so that's part of the problem here, is that what's going on under Jingles now is it's not actually figuring out whether there's an unfair effect based on race. It's figuring out whether there's an unfair effect based on party. And again, the Robinson case perfectly illustrates this. Justice Alito, as you pointed out, incumbency protection has long been recognized as a traditional race-neutral principle. Well, the plaintiffs' illustrative maps in Robinson totally departed from incumbency protection because every map they provided would take the state from a 5-1 map to a 4-2 map and require displacing some Republican incumbent.
Counsel. And Justice Kavanaugh pointed to page 2425 of your brief as well. We didn't grant cert on redoing Jingles. We granted cert on a totally different question. And we have said over and over again that statutory precedents are entitled to far greater stare decisis protection. Whatever mistakes we have in Jingles, Congress has had 40 years to fix them, and it hasn't done it. In fact, when they thought we did something wrong, they overruled it and passed Section 2. I don't know how we get to redo Jingles when this case didn't involve Jingles. The district court in this case didn't apply Jingles. It was the district court in the Robinson's case, and it's not the Robinson's case that's before us. It's this case. And so I'm a little bit confused. How do we enter redoing Jingles?
So the reason you're there is you asked two questions. One is why it's relevant, and the second is can you do it under stare decisis. So let me address those in turn.
You can do it in whatever order.
Okay. So
tell me, did the district court here apply Jingles?
No, because this case comes up as a racial gerrymandering case brought by the Callais plaintiffs. They showed that race predominated.
But that has nothing to do with what the court did here.
It does. The reason it does is because once they showed that race predominated, the burden flipped to the Robinson appellants to show that they had a compelling interest.
Right.
They asserted the compelling interest was Section 2, but if they misapplied Section 2, then they don't have a compelling interest.
But we have said over and over again that the compelling interest is in a state believing that it should remedy something, and it can be wrong.
Not as a matter of law.
We have said that over and over again. Counsel, you're wrong sometimes on a factual basis, sometimes on a legal basis. Wrong is wrong. Whatever you think might be the error, if you still think that it's something that's in your best interest to do, you do it.
Your Honor, that's contrary to this Court's holdings in Miller, in Shaw II, and in Cooper. This Court has repeatedly said that if you have an incorrect reading of Section 2 or Section 5 of the Voting Rights Act, that is not a compelling interest. The Court has applied the good faith standard under strict scrutiny to errors of fact, not errors of law. In Miller and Shaw, the DOJ browbeat states into creating multiple majority-minority districts, and they all thought they were doing it under Section 5. They were acting in good faith. The DOJ was browbeating them. But this Court said that is not a compelling interest because the DOJ was wrong about what Section 5 meant.
That hasn't been the allegation here.
That is the allegation here. The allegation here is that the Robinson Court was wrong about what Section 2 meant. They completely misapplied Section 2, even actually under Milligan, let alone under the proper way to interpret Section 2. Again, Justice Alito, 3 points. First, they ignored incumbency protection. If you look at what the district court said, they said they protected incumbency because Julia Letlow could still live in her district. She would lose, but she could still live there. That's not incumbency protection. 2, they did the exact thing that this Court held in LULAC is not a compact district. As you said, they took blacks from Baton Rouge and blacks at the north of the state and jammed them together. Yeah, it's a nice rectangular district. It's very pretty, but it's not compact. And then third, they didn't control for racially polarized voting. So they just said that blacks vote differently from whites, which just basically means Democrats in Louisiana vote differently from Republicans in Louisiana. That's not racially polarized voting. That is not the proper interpretation of Section 2, and it is exactly why Section 2 is leading to racially predominant results, where you're essentially using Section 2 to undo political outcomes. And that is an unconstitutional reading of the statute. And so the reason to get to your first part of your question, why should you revisit Jingles? Because we don't think it's consistent with stare decisis to say, well, we misinterpreted the statute 40 years ago, so now the statute's unconstitutional. Stare decisis is about respect for Congress and respect for stability. If this Court has created a constitutional problem in the statute, this Court should fix it.
Can you say more about why there's a constitutional problem with the statute?
Yes. So, as I was saying, the problem here is Jingles, as it's been interpreted, essentially imposes liability based on making the state take race and predominate over race-neutral criteria. Again, using Robinson as an example.
I don't understand. I'm sorry.
So, incumbency protection is a traditional neutral principle. Robinson found liability by requiring the state to discard their race-neutral.
But I thought you said Robinson was wrong, so then we just changed that understanding. Why does that create a constitutional problem?
So the way it was wrong is it required the state to subordinate race-neutral principles to race. And let me use Milligan.
And we say, and Jingles requires that?
So the way.
So it was consistent with Jingles, and Jingles is wrong, or it was inconsistent with Jingles, and we should say that.
It's the interpretation of Jingles that was adopted in Milligan is the real problem here. And so this is the pages in our brief that Justice Kavanaugh cited a couple times. The fundamental problem is when this Court said in Milligan that as long as the plaintiff's illustrative map is roughly equivalent to the state's map, that's enough to satisfy Jingles. What that meant is you're basically telling the state that you have to subordinate your weighing of your neutral principles and go a different direction just because of race. Let me give you an analogy that I think will make this a little bit clearer. Imagine if Congress had passed a statute that said LSU, if you have a white student and a black student who are roughly equivalent on your admissions criteria, you must pick the black student. Of course that would be unconstitutional. That would be subordinating
Yeah, but do you agree with my view that under Section 2, you're not alone mandating a particular result, that Section 2 is just about identifying the problem?
And I agree with that.
If that's the case, then it doesn't matter that the Section 2 analysis is showing you that there could be another way to do this.
It depends what you define as the problem. And the problem with Section 2 as construed in Jingles and Milligan is they are defining as a problem that there's another way of drawing the district that would help blacks, even though there's no reason to think that it's either intentionally discriminatory or even a significant risk of intentional discrimination.
But why is intentional discrimination the bedrock? They're not just – you're reducing what is happening to Section 2 to something that I don't think is consistent with what Jingles is actually requiring.
Because the Constitution prohibits intentional discrimination, and Justice Barrett, as you pointed out, this is enforcement legislation. So we agree it's not an intent test. But it has to at least be smoking out conduct that presents a significant risk of intentional discrimination. That's the phrase that this Court used in Bernie. It's the phrase that this Court used in Katzenbach, too. Again, one way of thinking about this is if you think there's a problem here, white Democrats in West Virginia, they don't get districts drawn for them. White Democrats have zero representation in West Virginia, even though they're a significant percentage of the state. The reason why Section 2, it's being construed in Jingles as a problem, is it's saying that you have to create a district for black Democrats that you would never create for white Democrats in a Republican state. It's essentially being used as a reverse partisan gerrymander on purely racial grounds. And that is a constitutional problem. And the test we have identified in our brief would solve that problem.
Thank you.
Thank you, counsel. You began, if I'm remembering correctly, suggesting that Milligan was consistent with your position in this case. And then, of course, you've mentioned its discussion of Jingles is not. Yeah. I wonder if you could explain that a little further, to what extent it's consistent and to what extent it's not.
Yeah, so most of the arguments we're making in this case were not made in that case and were not rejected in that case. There is one aspect of our argument that is inconsistent with Jingles, with Milligan. The one aspect that's inconsistent is what I was discussing earlier. The part of Milligan where it said that it's reasonably configured so long as it's roughly equivalent. We think that that is wrong, and we think that that aspect of the opinion is what causes all the racial predominance. Because, again, if you take a step back and think about two possibilities, possibility one is the plaintiffs come in and their map is superior to the state's map on the state's own principles. Then we think it's okay to have a results test, because in that circumstance, you're not telling the state they have to subordinate their race-neutral principles. You're essentially enforcing their own race-neutral principles in a situation where there is either intentional discrimination or at least a significant risk of intentional discrimination. But conversely, in a situation where it's equivalent, you're basically telling the state, look, you could have done this either way. You want to do it way A, you have to do it way B. Why? Only because of race. That's what makes it predominant. And that's the one aspect of Milligan that we disagree with. But
Thank you. Justice Thomas? Justice Alito?
Well, I think you may be too hard on Milligan, because Alabama in Milligan did not argue that it had drawn those maps based on seeking partisan advantage, right?
I agree, right? And that's why I started my answer to the Chief Justice by saying all the arguments we're making here were not made by Alabama. Alabama made a series of much broader arguments about how you can't consider race at all, the plaintiffs have to draw their maps race blind, you ultimately have to find intent. We're not arguing any of that, and I agree with you. Alabama, for whatever reason, didn't argue that incumbency protection and partisan advantage were the reasons for their map. And after Rucho, it's clear that those are traditional race-neutral principles that cannot be subordinated by Section 2.
Yeah, and I think that's consistent with the fundamental analysis in Milligan for reasons that I tried to bring out during my questioning of Ms. Nelson. The first Gingell's precondition, as described correctly in Milligan, is that the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district, and a district is reasonably configured if it comports with traditional districting criteria. And since Rucho, seeking a partisan advantage is a permissible legislative objective, just like incumbent protection. So therefore, that should figure in the first Gingell's precondition.
It absolutely should. And in this case, in Robinson in particular, the state did argue incumbency protection. And if you look at what the Robinson District Court said, it actually said that, we satisfied incumbency protection. She still lives in the district. She's going to lose, but she still lives there. That can't possibly be right.
And then again, on block voting, again, the Rucho issue was not involved in Milligan, but if block voting is understood properly to mean voting on the basis of race but not on the basis of partisan politics, then that must also be considered under Gingell's, right?
Absolutely. And it matters, right? Because on our position, again, we agree that Section 2 can have a constitutional scope, and our view of the results test would apply in exactly the situation where racially polarized voting properly understood exists. So think of an area like Harlem, for example, you've got white Democrats, black Democrats, and Hispanic Democrats who all live around the same area and who probably have, at least sometimes, different candidates of choice. If the state of New York were to draw a map in a way that departs from their normal principles and favors one of those racial groups, that's the sort of situation where Section 2 could come in and say, well, there's racially polarized voting. You've departed from traditional principles. There's a reason to be worried. And this isn't just a partisan thing. You can imagine the same thing on the Republican side. Imagine Florida. If you have a part of Florida where you have white Republicans and Hispanic Republicans, and same thing, the Florida legislature draws it in a way that departs from traditional principles and favors one or the other racial group. But what you can't have is merely just showing that a Republican legislature favored Republicans with whether or not they're white or black. And there's just no reason in the world to think that the Louisiana legislature would have done anything different in this case if every black Democrat in Louisiana was a white Democrat.
Let me ask you about congruence and proportionality. So the 15th Amendment pretty clearly requires intentional discrimination. And the 1982 amendment to the Voting Rights Act walked away from intentional discrimination. But my reading of your position is that Congress's enforcement power under Section 2 of the 15th Amendment allows it to go beyond intentional discrimination for this reason. Proving intentional discrimination is difficult in part because it's really hard, it's always hard to figure out what legislative intent is. What was the intent of the legislature in enacting a map? Do you look at stray statements here or there by legislators, plus a finding of intentional discrimination accuses the state of a serious wrongdoing? So it's permissible to go beyond intentional discrimination to this extent, to identify factors that strongly support a finding of intentional discrimination. And that's what was involved in White versus Register, which figured very prominently in the drafting of the 1982 amendment. So if that's what you're doing, it is congruent and proportional in that respect. Is that a correct understanding?
That is, and if I could just amplify a couple of points. So we agree the Constitution prohibits intent. Congress's enforcement power can let them go beyond that to an effects test, a properly tailored one that gets at a significant risk. And that avoids a lot of the difficulties of actually having to prove intent by a preponderance of the evidence. And if it is actually tailored, if the statute itself is tailored to things that have a significant risk, then we don't actually think you necessarily need to have a temporal limit in the statute itself. So that's why, Justice Sotomayor, for example, the bans on tests, literacy tests, we think those are fine even though there's no end date in that statute because those are well-known, highly likely to be intentionally discriminatory laws, even if they're not always. But the problem we have here is that the way Section 2 has been construed under Jingles and its progeny is so far from the things that are likely intentionally discriminatory and indeed are affirmatively compelling gerrymanders that are unconstitutional. If that is ever permissible, it could only have been based on the centuries' worth of discrimination that existed in 1965.
One final question. I'm sorry to take up so much time, but I would like you to address what Solicitor General Aguinaga said about the practical problems he fears your approach would cause.
So I'm not sure I really understand what his concerns are. I think the way we've articulated the test, the plaintiffs have to come in and show that they have a map that is superior to the state's map on the state's own race-neutral principles, including its political objectives. I think the thing that the Solicitor General primarily focused on is confusion about what it means to be predominant. I think we agree completely with them that the phrasing of the standard is race a criteria that could not be compromised? Have you subordinated race to traditional principles? And if you apply that test, I'm not saying that there won't be difficulties on the margins of how to apply it. There will be new cases. Your Honor wrote the opinion for this court in Brinovich. It was the first time that the court had ever adopted a test for vote denial under Section 2. I'm sure there were cases afterwards, but that test was well tailored to the text of the statute and its purposes. And what we're essentially saying in this case is you should do to Section 2 as opposed to vote dilution what the court has already done as applied to vote denial. It should adopt a test that's tailored.
Thank you.
Justice Sotomayor?
The bottom line is just get rid of Section 2, because the test you're providing doesn't do anything for the effects test that Congress identified. We did say in Kassenbach, we've said it repeatedly, that legislation need only be plainly adapted to addressing discrimination practices in voting, right?
Yes.
All right? The standard that you're setting is a much different one. It has to substantially be addressing this issue. Number two, what you're suggesting is that people of one race, blacks in Louisiana, who will have to be 51% of the population before they'll be able to elect another black candidate. Because what you're saying is partisanship is non-negotiable. You have to create maps where you're going to have 6 districts out of 7 always white, because that's our partisanship. That means blacks never have a chance, no matter what their number is, until they reach more than 51%.
So I don't think that's true for a lot of reasons, Your Honor. So the first is, as I think the General pointed out, even without Section 2, there's no reason to assume that states are going to try to crack every single majority-minority district. And the reason why
the illustrative maps showed that a map drawn without looking at race and partisanship together would have created 2 districts.
Your Honor,
Compact in all traditional ways, it would have been District 2 and District 6 around the Baton Rouge and 2 other counties that were tied historically and otherwise. And politics, you say, not race, is what led the state not to give them another district.
So I'll say several things, Your Honor. First, I don't agree with your characterization that the illustrative maps were compact. They combined blacks in different parts of the state, just the way this Court said
No,
you
you're
can't
talking
do that.
about the state's chosen map.
No, I'm not.
The map
plaintiff's
that
illustrative map, if
the
you look at
illustrative
District
map
5.
was better. The illustrative map, 2 and 6 were combined. But 2, even in the original map, was not all that compact.
Justice Sotomayor, as Justice Alito pointed out, I'm not disputing the compactness of the district. I agree they drew a very pretty rectangle. The problem is that in the very pretty rectangle, the blacks lived in the south and the north. And they took 2 very different groups of black people and put them together.
Well, the problem is that all of this map is that way. North and
right,
south,
but they did it for
east
racial
and west.
reasons, and the state did it for non-racial reasons.
Well, really, in excluding the blacks, they did it for racial reasons.
No, Your Honor, there's no argument for that. As Justice Alito pointed out, the state's maps have been pre-cleared twice by the Department of Justice. So the suggestion that the fact that the prior maps were 5-1 maps is not – there's no basis to say that that was for racial reasons. And again, West Virginia, 0 Democratic districts. There's a lot of white Democrats in West Virginia. There's just no reason to assume that because there's a large Democratic population in Louisiana that doesn't have a district, that that's a racial reason rather than a partisan reason.
If you can't separate out the 2, it's impossible.
But you can separate out the 2. You can control for party, and you can require them to draw a map that meets the political objectives. And again, and the last thing that you said earlier, that means Section 2 has no effect. That's not true. The examples I gave you earlier about areas like Harlem and in Florida where you have of the same party and of the state that controls that party, differences in the races, that's where Section 2 does work. And by the way, that was sort of in Jingles. In Jingles, there was showing you could control for partisan effect. There was racially polarized voting even within the Democratic Party. That's where Section 2 matters, where you have a reason to think that a racial group is being treated.
You have some of that here, too. You have proof of that here.
No, you don't. What you have here is that Republicans and Democrats are different. There's
No, you have some that even white Republicans or white Democrats won't vote for black candidates.
Right, but if these were white Democrats, there's no reason to think they would have a second district. None. And so what is happening here is their argument is because these Democrats happen to be black, they get a second district. If they were all white, we all agree they wouldn't get a second district. That is literally the definition of race subordinating traditional principles.
Justice Kagan?
Mr. Mooppan, just a quick, possibly digressive question. You're not contesting that if a state uses and predominantly uses race-based criteria in order to achieve partisan goals, that's
Agree. That's
impermissible
under Cooper in a bunch of cases. And we
okay.
agree with that.
That's all I wanted to know.
Mrs. Gorsuch?
Just a couple of questions about the practical implications that Justice Alito is touching on and some of your colleagues have as well. How do we control for state political objectives? I mean, you say, well, that's easy to do. Is it the number of incumbent seats that they want to protect? Is it the level at which they think protection is appropriate? Say, I need 55% of the population to be registered Republicans or Democrats. Do they get to say that? Does the state get to say, I not only want 5 incumbents protected, but I want them really protected? That's one example. You know, does the state have to say that when it's legislating, or can it come in later in the litigation and say that? Can a court, and I'm just spinning out a few things for you, you can just respond to them how you want. Can a court second-guess those and say, those are not really the state's purposes, that they're just litigation position? How's a court supposed to handle that? And then I've got some more for you.
So the same way this court already handles that in racial gerrymandering cases like Alexander. Yes, the state can come in with whatever their political objectives are. If they want to say it's not just a 6-1 map, it's a 6-1 map with a certain percentage because we want to make sure certain people are safe, really safe, and we're willing to tolerate a little bit more risk elsewhere, it's up to them to set what their political objectives are as long as they are race neutral. Now, can a court second-guess that? Yes. If they say, look, these are our interests, and the map as drawn is inconsistent with that in a bunch of ways, a court could say we don't believe that.
Well, what if the map is consistent with it? Can I still try and disprove it?
Well,
so
no.
That wasn't really, I mean, that's what the map does, but that's not really what they were after.
So if you could try, if you could try to bring an intentional discrimination case and say that it's pretextual.
How about cohesion, right? You know, you say, well, you got to segregate out members of one race or another based on their party affiliations and crossover voting and how much they really won't vote for somebody of the other race even if they're the same party. How much cohesion is enough? I mean, very rarely is it going to be that there's zero crossover voting and 100% cohesion, and vice versa. It's going to be areas of gray. And are we then into a business perhaps of stereotyping?
So the court's never made clear what level of cohesion is
necessary.
Know. I think the right way...
That's why I'm asking you.
Right. I think the right way to think about it analytically is if the plaintiffs have an illustrative map that satisfies our first criteria, right? That they're...
Yep. No, this is another criteria.
Right. So assuming they've satisfied that, then the question is there enough black cohesiveness that they can win the district? So you would have to look to see how much black cohesion is there and how much white crossover voting is there. And if together they can predictably and safely win the district, then they've satisfied...
What's predictably and safely? I mean, those are nice qualifying words. I mean, does it have to be just 50 plus 1? Does it have to be 60? You know,
well,
I mean,
so how
does a judge make that decision?
I think the courts, what they've usually done is looked at how the map would have performed in prior elections. You don't just look at one because there can be...
Oh, you can run thousands of these things. I mean, we've got computers now. I mean, goodness, of course. And you're going to have data points all over the place. But a judge is going to have to draw a line. And I'm wondering how the judge draws that line.
So we have lots of concerns with how Jingles is applied over time, but this isn't one of them. This seems to have been...
Well, this will be the next problem if we go your way, is all I'm suggesting.
I don't think so, Your Honor. And if your concern is, well, instead let's just scrap Section 2 entirely.
No, I'm not asking that. That isn't my question. I'm asking... I'm listening to everything everybody is telling me. I'm asking you about your proposal.
Right. And so I guess my point is, if the concern with our proposal is that you will have to answer cohesiveness questions that require some amount of empirical showing, what's the alternative?
Okay. And I got it. It's always the bear. I'm outrunning a bear. I got it. Okay. Predominance. What does that mean? I know it's throughout our case law, and I know you say it can't be compromised. Is that a but-for causation test? Is that a proximate causation test? What is it?
I don't think it's but-for. I think...
Well, but-for can't be compromised. It means it's an essential component. It wouldn't have happened but-for. Okay, so it's not but-for.
It's not but-for. The way the Court has described it as...
Is it a proximate cause?
I don't think that's the right way of thinking about it.
It's not a proximate cause. So what is it?
I think the way the court has described it is it's a factor that could not be compromised and where race-neutral principles were subordinated to it. So this case is a very easy case to analyze that because the race-neutral principles of incumbency protection were
I'm not worried.
Okay.
I'm focusing on your test
yes.
going forward, not this case.
So let me help you this way then. Because I think the question is when is predominance not satisfied where race is considered? I'll give you two examples.
Yeah, I mean, under our normal equal protection jurisprudence, we don't ask whether race predominated. Right. We say you don't discriminate on the basis of race, period.
So let me give you two examples where race is considered, but under the predominance test it wouldn't be satisfied. And that's why, for example, this court has said that the intentional creation of a majority-minority district does not alone show predominance, and we agree with them about that. So here's one example. The map drawer doesn't consider race at all, uses race-neutral principles. The computer spits out two maps that are totally equivalent. To pick between them, they say, okay, we'll use the one that has a majority.
But that gives rise to an inference of intentional discrimination. There's no other explanation that can be provided in your hypothetical. That's intentional discrimination. That's not predominance. That's choosing on the basis of race.
Neither of this court's formulations of predominance are met on that fact pattern. You can't say that race-neutral principles were subordinated. They weren't. And you can't say that the race was non-negotiable. It wasn't. So that's one example. Another example would be if you use race-neutral principles and the best map happens to be a majority-minority district, and then someone tries to say, don't draw that map, draw a different map for some other reason, and they say, no, we don't want to do that. We don't want to get rid of a black district.
That's intentional as well. Okay.
Again, I agree with you. My whole point is what this court has said again and again and again.
Oh, I know what it said.
Okay.
I just don't know what it means.
I think it means exactly what I'm saying, that it's not enough for it to be intent. Okay. It has to be that race-neutral principles are subordinated to race.
Thank you.
Justice Kavanaugh?
Well, I'm going to pick up right there because I had a lot of questions about your use of the word predominance as well, which the amicus briefs on your side say that word has been hopeless, I think, in trying to figure out what it means. What I've understood it to mean over time in the jurisprudence in this area is that race does not predominate if the district, even though drawn based on race, is reasonably configured and compact. Is that what you think?
Yes and no, right? So
that's not as helpful.
I know. And so here's the issue. This court has recognized the test is whether race-neutral principles are subordinated to race. If you don't comply with traditional principles, then clearly you have subordination. But what this court held in cases like Bethune, Hill, and Cooper, and we agree with that, is if you just are dead set on drawing a 55% black district, but you manage to do it in a way that's consistent with traditional principles, that is still racial subordination. But here's the really important point for this case. We are not arguing, absolutely not arguing, what Alabama argued in Milligan, which is that the plaintiffs can't consider race, and that the plaintiffs can't have a 55%.
I understand that.
And what does matter
but it
is what
seems
the court
like your position is you can use, the state can use race a little bit.
If we're talking about the state
it's kind
acting,
of like the Bakke kind of thing. It's a race.
Yes. If you're talking about the state acting in the first instance wholly apart from Section 2, yes, our position and this court's position has been you can consider race, and the reason why is because redistricting is a complicated, multi-factor inquiry where lots of the permissible factors highly correlate to race, and if you don't have a standard like predominance, as this court recognized in Alexandria, every partisan gerrymander case will become a racial gerrymander case because they will always come in and say, aha, you must have considered.
But where it predominates, I'm repeating myself now, is where the district becomes not compact, not reasonably configured?
That is one way it becomes race doesn't predominate. The other way is if they just set out to say, I'm going to draw a 55% black district, and then they backfill from there. Because
that's race predominating.
Exactly.
Yeah.
But importantly for our purposes, in a Section 2 case, when we say that race can't predominate in the step 1 of Jingles, we are not focused on what the plaintiffs do. The plaintiffs can absolutely consider race.
I got that.
The court has to conclude that their map is better than the state's map. And then you avoid predominance.
I got that. Okay. So then what I viewed as the real innovation of your brief that we have not considered before, as you point out, is the material on page 25, the political objectives. Yes. And that strikes me as new, but also new because we haven't considered it before.
So I think that's right. I don't think this Court has ever squarely considered it. I think part of the reason the Court has
What's the rationale for why it's consistent for what we have allowed before?
Because it is another traditional race-neutral principle. It is one that hasn't been urged as frequently, in part because it was unclear whether partisan gerrymandering...
Because of Rucho. I mean, pre-Rucho.
Right, pre-Rucho. But post-Rucho, it is totally clear that that is a permissible criteria. Indeed, in Rucho, the Court described it as ignoring the good faith inference that the legislatures do to not consider their political objectives.
Got it. And is it also, though, part of constitutional avoidance?
Yes, again, because...
So there are two things. It's hasn't been considered before, and it avoids constitutional problems if we fold page 25.
That's absolutely right. Again, I think one thing to remember here is Jingles was written in 1985. It was 10 years before this Court wrote Shaw and Miller and all the predominance cases. There's just no way Jingles would have ever been written the way it was if it was decided after those cases.
Okay.
That is an intervening change in law that has created constitutional issues, and I think the Court should modify Jingles to reflect that.
Got it. Two more. Sorry. Do you agree with Louisiana on the Constitution?
In part, but not entirely.
Can you explain that?
Yeah. So we don't think that it is unconstitutional for Congress to have any results test, or that the current results test can't survive if it's construed the way we've proposed.
What if it were not construed the way you want it to be construed? What is your position on the temporal point?
So if it was construed differently than we've proposed, we do think it's unconstitutional, both because of the temporal point and because of its scope just to begin with. Right?
To be clear, you're not saying Section 2 is unconstitutional. Section 2, as applied to redistricting to the extent it requires the intentional use of race to create districts, if there's no change in Jingles, that's your position.
I agree with all of that, except instead of the word intentional, I would say use the word predominant. But with that caveat, yes.
Yes, got that. Okay, last, this is picking up on Justice Gorsuch. I think your Harlem hypo is very challenging because, I mean, you get into elections and you're microanalyzing the data. White Democrats and black Democrats are not necessarily – there's going to be a lot of times differences in that, and you say that triggers the finding of polarization, correct?
Yeah, if there is –
I mean, how big a difference does that have to be?
Again, I think the right way of –
It's like 10-point difference?
I think the right way of thinking about it is if you start with their step one, which is – what would the map look like if they'd done it on race-neutral grounds, and then say, is there enough polarization that the minority group who would have been in that district could have won, then they can satisfy steps 1 and 2.
Thank you.
If there's one last point I can make, Your Honor, which you had asked a question earlier about the practical consequences of our position. I just do want to emphasize one thing about that, which is if you look at Congress today, there are roughly 60 black representatives. If you look at the districts, there are only 15 majority black districts. So even if we're not even urging Section 2 to be eliminated, but even if you eliminated Section 2 entirely, fully 75% of the black congressmen in this country are in districts that are not protected by Section 2. So it is simply not the case that adopting any of the positions on this side, let alone our position. Just
to be fair, they're not arguing for eliminating Section 2 entirely. I think they would disagree with that characterization.
But under any view of it, none of these positions is going to lead to there being no black representation in Congress or anything remotely approaching that.
Thank you, counsel. Justice Barrett?
Mr. Mooppan, I have one hopefully very straightforward question. It's really just to clarify. You've said, and you said just now to Justice Kavanaugh, and, you know, I take this to be in your brief, too, that your position would require a modification of Jingles. Is that necessarily true? Is there a way to say it's a clarification of Jingles? I mean, Jingles is a, 40-year-old precedent. So, big ask to change it.
Yeah. So most of what we are urging, I think, could be described as a clarification. So we have 3 key points in our brief. One is about how you do recently configured. The second is about how you do racially polarized voting, and the third is how you do the totality of circumstances inquiry. The last 2, I think, can fairly be described as a clarification because the Court has never really grappled with exactly how the totality works, and it has expressly left open the question of racially polarized voting. As to the first part, the reasonably configured, Most of what we're saying is consistent with most of this Court's cases, but after Milligan, I do have to acknowledge that that aspect of what we're urging, that it's not enough that it be reasonably equivalent, that the plaintiff's map has to be superior, that is undoubtedly a modification. But I would say it is no greater of a modification than, for example, what this Court did in Kaiser when it retained our but tweaked it in various ways. So I certainly think it's consistent with stare decisis.
Okay, thank you.
Justice Barrett?
That was tweaking.
Sorry, Justice Jackson.
Sorry. The plaintiff's map has to be superior in your view under this new part insofar as it uses race-neutral criteria. Is that what you mean?
Yes.
And that's what was asked for by Alabama. And so you'd be saying that that would require a change to what we said.
No, Alabama didn't argue that. The problem with what Alabama argued is Alabama basically said the plaintiffs had to come up in court and without considering race at all, somehow magically show up with the 50% district. We're not arguing that, and it didn't make much sense, so it's not surprising.
Oh, I thought they were saying you had to have race-neutral drawing. That was the whole thing about the computers.
No, so they had some weird thing about computers, which, again, is not what we're arguing.
But it's crucial to this point. Their weird thing about computers was you have to demonstrate as the plaintiff that you have a race-neutral map, and that's what you're saying right now.
It's a very different thing. Yes, they both use the word race-neutral, but what Alabama did was something about computers that I frankly don't understand. What we are arguing is simply under the state's own principles,
right,
their map has to be better. That I do understand.
All right, and then my final question, it just goes to that point, because I'm struck by your the degree to which your analysis relies on the state's departing from traditional principles. You say you get to Section 2 when they Section 2 violation when they do that. And I guess I just wonder why that doesn't leave us in a position where you really cannot remedy the effects of race discrimination operating in a district based on past discriminatory choices. In other words, you're still bringing in intent because you're saying you have to intentionally depart from your traditional principles on the basis of race, and that's what's going to trigger Section 2. And I have, for example, the Louisiana historian's brief, where it talks about how the reason why you have blacks in different places is because the residential patterns in the state are still reflective of where enslaved communities lived along this particular river system. And that residential segregation, along with disparities in political power, economic status, health outcomes, all of these things are existent today because they reflect institutional choices that are traceable to Jim Crow and reproduced through contemporary practices. That last part is a quote from them. So I appreciate that you want to say when the state comes with their new map, we have to look at the extent to which in drawing it they have departed from traditional principles on racial grounds. What I'm suggesting is what do we do with the situation in which the state keeps presenting the same map? They're not departing. Their map looks fine. But because of all of these race-based effects, because of the history of Jim Crow, which I appreciate happened a long time ago, but I'm positing, and Jingles allows for us to see where those effects are still occurring. I hear your test not allowing us to solve for that problem when the state is continuing to present the same map under circumstances in which people are not actually being able to have equal electoral opportunity.
So I guess I'll say three things about that, Your Honor. The first is, again, our position it does not require intent. I agree that at step one we're saying you have to consider race-neutral principles, but if they've departed from that, we think you could find liability based on the effect without making a finding that they did it for intentional discriminatory reasons. Now, second, you pointed to the fact that it's possible that these effects stem from long distance.
Can I just ask you, why do they have to depart? What if they just keep on doing the same thing? They're not changing the map. I thought Section 2's whole point was that you got to offer a remedy. You got to have a remedy where this thing is happening. So the well-intentioned state with no intent to discriminate says the census has changed, this is where people live, but we're just going to provide our same map. And if we can determine that that map, under those circumstances, is not providing for electoral opportunity, regardless of whether they've departed from traditional principles, I thought you had to solve for that.
And I guess our point is you don't.
You don't. It's only where they depart from traditional principles.
It's only where you could say that it's either intentionally or likely intentionally discriminatory.
So intent does come in.
You don't have to prove it by a preponderance of the evidence.
I see.
It's any other results test.
Thank you.
Thank you.
Thank you, counsel.